Hey everyone, and welcome back. It's like a safeguard to prevent unnecessary procedures and costs.
And in California, it's not optional.
Oh, really?
It's the law.
Wow.
Employers and their claims administrators have to have these UR programs in place, and they have to follow strict timelines and guidelines.
Okay, that makes sense. Now, here's something I found kind of interesting.
Okay.
Anyone in the UR organization, even if they're not a doctor, can actually approve a treatment request.
Right, so there is that.
Like, that seemed a little surprising to me at first.
It's important to clarify that while anyone can approve a treatment,
Okay.
only a doctor can deny or modify a treatment request.
Got it.
And there are also rules in place about matching the reviewer's specialty to the treating physician's specialty.
Oh, that's good to know.
So you're getting a fair evaluation from someone who understands your specific injury or condition.
Okay, so let's say my doctor requests authorization for a treatment, but maybe the request is missing some info. Like maybe they forgot to include a test result or something.
That happens sometimes.
Yeah, what happens then?
The UR organization can request that missing information.
Mm-hmm.
They have 5 business days to make that request, and your doctor then has 14 calendar days to respond.
Oh, wow. So those timelines are pretty strict.
They are, and if they don't meet that deadline, the request can actually be denied.
Wow. So it's really important to make sure everything's there from the beginning.
Absolutely. Having a really complete request from the beginning can prevent those delays.
Intense. So let's say the UR reviewer looks at everything and decides to deny or modify the treatment.
Okay.
What happens next?
You're going to get a written notice explaining the denial or modification.
Okay.
This is a really important document.
Okay.
Not only does it have to explain the reason for the decision, it also has to give the clinical rationale behind it and cite the specific treatment guidelines they use.
So it's not just a no, it's a no with an explanation.
Exactly. They have to justify their decision based on these established guidelines.
Okay.
One of the key guidelines they use is the MTUS.
So what?
The MTUS, or Medical Treatment Utilization Schedule, that's kind of like the gold standard for treatment guidelines in California.
Got it. So this notice explains why they made their decision.
Right.
What else should I know about this notice as the injured worker?
Well, this notice is more than just an explanation. It also outlines your options.
Oh, okay.
For example, it'll tell your doctor how to contact the reviewer
Okay.
if they want to discuss the decision.
So there's room for some back and forth.
Absolutely.
Okay.
And for you, the injured worker, the notice has to explain how to formally object to the decision.
Okay, so that's my right as the worker,
Exactly. And that leads to the next step in the process.
which is,
Independent medical review, or IMR.
all right, IMR. This is where it gets interesting.
Yeah.
So tell me more about IMR. How does it work?
So before 2013,
Okay.
if you disagreed with a UR decision, you might have had to go to court
Oh, wow.
to fight for the treatment. But in 2013, California made a change.
Okay.
They replaced that court process with IMR. And here's the thing, the employer pays for this review, not you.
Oh, that's a big difference.
It is.
So IMR is meant to be more accessible,
Exactly.
less intimidating.
It's about getting a fair medical opinion.
So let's say I'm not happy with the UR decision.
Yeah.
How do I start this IMR process?
So first remember, it's the injured worker or their representative
Oh.
who starts IMR.
Got it.
And it only happens after a UR denial, delay, or modification.
So UR is always the first step.
Always the first step.
Okay.
And you have 30 days to file an application for IMR after that UR decision.
Okay. 30 days.
30 days.
Got it. And what does that application need to have?
It needs a signed form from you
Okay.
and a copy of that UR denial notice.
Okay. So I send all that in. What happens next?
Well, it goes to the administrative director or the AD.
Okay.
Their job is to make sure that your case qualifies for IMR.
So they check if everything's in order.
Exactly. They're making sure you filed on time, that the application is signed, and that there aren't any other issues.
Got it. So if everything's good to go.
If everything checks out, they'll request your medical records from the claims administrator.
Hmm.
Usually for the past 6 months leading up to the treatment request.
So they really want to get a clear picture of what's been going on.
Yeah, and your doctor or your lawyer can also submit medical records if you think they're relevant to the case.
Okay, good to know. So they gather all those records and then what?
Then they assign your case to an expert reviewer.
Okay, so this is a doctor.
It's a licensed physician who is actively practicing and has expertise in your condition.
So they're a specialist.
Right. And just to make sure everything's fair, they can't be someone who also does qualified medical evaluations or QMEs.
Right. That makes sense. I wouldn't want someone who's already involved in my case to be the one making this decision.
Exactly. So everything stays impartial.
Okay, now this is interesting too. You mentioned earlier that IMR decisions are actually available online.
They are
Publicly
available.
So anyone can see them.
Well, they remove all your personal information, of course.
Of course.
But this transparency is really good for you
Okay, how so?
because you can actually research past decisions.
Oh, interesting.
And see how reviewers have applied the guidelines to similar cases.
So it's like having a bunch of case studies to look at.
It really is. You can get a better sense of what to expect
Mm.
and understand the reasoning behind these decisions.
That's really helpful. So I'm picturing this expert reviewer looking at my records. They're looking at the treatment request, and they're looking at those guidelines, especially the MTUS.
Uh-huh.
So what criteria are they using to make this decision?
So they're looking at a few key things. Is the treatment medically necessary?
Okay.
And they can't just go with their gut feeling.
All right.
They have to base it on what's called evidence-based medicine.
Okay, so there needs to be research and science backing it up.
Absolutely. And California has a hierarchy of medical evidence standards,
Yeah.
and at the top of that is the MTUS.
Okay, so they've got this whole framework
Yes.
to help them make this decision.
Yes, and they have to justify their decision in writing.
Okay.
It can't just be approved or denied.
Right.
They have to explain why. And it has to be within those timelines, right? 30 days for regular IMR, 72 hours for expedited cases.
Correct.
But what happens if, after all that, I still disagree with the IMR decision?
Oh, you still have options, and that's where the appeals process comes in.
Okay, so we'll dive into that appeals process in the next part of our deep dive.
We will.
So stay tuned.
Sounds good. All right, so before the break, we were talking about what happens if you disagree with that IMR decision.
Right, because even with all these safeguards in place, you might still not agree with the expert reviewer.
Right, and that's okay.
Yeah.
You still have options. So
Okay, good.
let's say you get that IMR decision, you read through it carefully, and you're just not convinced you still think the treatment is necessary.
Uh-huh.
What do you do?
Well, it sounds like there's an appeals process, right?
Yes, there is.
Is that where the WCAB comes in?
You got it. The WCAB, or the Workers' Compensation Appeals Board. It's like the court system for workers' comp cases in California.
Okay.
So if you disagree with that IMR decision, you can file a petition with a WCAD judge
Oh.
within 30 days of getting that decision.
20 days, got it.
Yeah,
Yeah.
it's basically saying, hey, I think there's been a mistake here.
Uh-huh.
I want a judge to look at this.
But I'm guessing it's not that simple, right?
Right. You can't just say, I disagree.
Right.
There have to be specific reasons for appealing.
Okay, what are those reasons?
So remember how we talked about the IMR decision being presumed correct?
Yeah.
That means you have to show the judge why the decision was wrong.
Okay, so what are some examples?
Well, one reason could be if the administrative director,
The AD?
yes, the AD overstepped their boundaries.
Okay.
Like if they approved an IMR application that shouldn't have been approved,
Right.
that could be grounds for appeal.
Okay, so it's making sure the AD is doing their job correctly.
Exactly. Another reason could be if there was fraud involved in the IMR process.
Ooh, that's serious.
Yeah, like if someone submitted fake medical records or lied to the reviewer, that would definitely be grounds for an appeal.
Okay, what else?
Well, you also want to make sure that the expert reviewer who made the decision was unbiased.
Of course.
So if you have evidence that the reviewer had a conflict of interest,
Okay.
that could also be grounds for an appeal.
Like what kind of conflict of interest?
Like maybe the reviewer was friends with the claims administrator
Oh.
or had worked for the employer in the past.
Got it. So no funny business.
Exactly. It needs to be a fair and impartial decision.
Uh-huh.
You can also appeal if the decision was biased against you based on things like your race, religion, gender, or disability.
Okay, so those protected characteristics are taken into consideration.
Absolutely. California has strong anti-discrimination laws, and those apply to the IMR process as well.
Okay, that makes sense. What else?
And finally, if you can prove that the IMR decision was just based on a factual error,
Oh.
that's a strong basis for appeal.
Like what?
Like maybe the reviewer misunderstood something in your medical records, or they misapplied the treatment guidelines.
So basically a mistake.
A mistake, yes. But you need evidence to back up your claim.
Okay, so I can't just say I disagree. I have to have proof.
Exactly.
Okay, so let's say I have a good reason and I file that petition with the WCAB.
Okay.
What happens next?
Well, the judge will review everything your petition, the IMR decision, and any evidence you submitted.
Okay.
They might also hold a hearing
Okay.
where you and the other side can present your arguments.
So it's like a mini trial.
It's similar, yeah.
Okay, and then the judge makes a decision.
Exactly.
So what can the judge actually do?
Well, if the judge agrees with you,
Uh-huh.
they could order a brand new IMR.
Oh, wow.
So your case goes back to the beginning
Okay.
and is reviewed by a different expert reviewer.
It's like starting over.
Exactly, a fresh start.
Okay. What else could the judge do?
They could also send the case back to the original IMR organization,
Okay.
but with specific instructions.
Oh, interesting.
Like, hey, you need to look at this part again.
Okay.
Or you need to consider this new evidence.
So it's not always a complete do-over.
Right, sometimes it's more of a course correction.
So the appeals process is there to make sure everything is fair.
It is. It's a safety net.
Okay, good to know. So we've talked about UR, IMR, and even the appeals process.
We have. It's a lot of information.
It's a complex system, but I think it's important to understand how it all works.
It is if you ever have to go through this process yourself.
Exactly. Knowledge is power, right?
Absolutely.
Now, before we wrap up this part,
Okay.
you mentioned earlier that those IMR decisions are publicly available online.
Right.
And you said that's a great resource for injured workers.
It is.
So can you explain a bit more about how someone would actually use those decisions?
Sure, it's kind of like legal research.
Okay.
Lawyers look at past court decisions to see how judges have ruled in similar cases.
Right.
You can do the same thing with IMR decisions.
Okay.
So let's say you're facing a UR denial for a specific treatment.
Uh,
You can go online and search for IMR decisions involving that same treatment.
so you're looking for precedents?
Exactly. You can see how other reviewers handled similar situations.
Okay.
You can see what arguments they found convincing, what evidence they used, and what their decision was.
Interesting.
Yeah, it can give you a better understanding of how your own case might be decided.
That's really helpful. So where can people find these IMR decisions?
The DWC, the California Division of Workers' Compensation,
Ah.
they have a website where they post all the IMR decisions.
Okay, and we'll put a link to that in the show notes.
Perfect.
Awesome. So we've covered a lot today. UR, IMR, and even the appeals process.
We have. It's a complex system.
It is, but I think it's designed to be thorough and fair
It is.
and to make sure injured workers get the right care.
Right.
So now in our final part, we're going to step back and look at the bigger picture.
Okay.
What if we could redesign this entire system from scratch?
Interesting.
What would the ideal system look like?
I like that.
Stay tuned for that. All right, so we're back, and we've been talking all about utilization review and independent medical review.
Lots of info.
Yeah, and how these processes work, why they're important, and what to do if you disagree with a decision.
Exactly. We've really gone through it all.
But now I want to shift gears a bit.
Okay.
We've talked about how the system works now,
Right.
but what if we could redesign it
Interesting.
from scratch?
Like start over completely.
Yeah, what would the ideal system look like?
I like that. Let's get creative.
Okay, so what features would we want to see?
I think the most important thing is to remember that this system is about people,
Absolutely.
injured workers who are going through a tough time
Right.
dealing with pain, uncertainty, stress.
So it needs to be designed with them in mind.
Absolutely.
So what would that look like practically?
Well, for one, it would be easy to understand.
Right.
We've talked about how complex it is now.
Uh-huh.
All of the timelines, the guidelines, the jargon.
Right.
In an ideal world, it would be clear and concise,
Okay.
easy to understand for everyone.
Yeah, like maybe a dedicated website or an app
That's a great idea.
that walks you through the process step by step.
Yeah. Answers questions, provides resources.
And speaking of technology,
Yeah.
I think that could play a huge role in making the system better.
Absolutely.
Like imagine submitting treatment requests online,
Oh, yeah.
tracking your case, communicating with everyone involved
That would be amazing.
through a secure portal,
Streamline everything.
Yeah.
Make it much more efficient.
and maybe even incorporate telemedicine
Oh, that's a good one.
so people could have virtual appointments.
Especially for people in rural areas or with mobility issues.
Yeah, that would be a game changer.
Absolutely.
So we've got user-friendly, tech-savvy, easy to access.
Mm-hmm.
What else is essential?
Transparency.
Okay,
Big time.
yeah, because right now it can feel like a black box.
It does.
You submit your request and you wait.
And you don't know what's happening.
Right, and it's frustrating.
Totally. So in an ideal system,
Yeah,
that decision-making process would be clear.
okay.
Maybe make those treatment guidelines easily accessible.
Like the MTUS.
Exactly. Explain it in plain language.
Right.
And require reviewers to give detailed explanations for their decisions.
So you know why they decided what they decided.
Absolutely. That builds trust.
Okay, so transparency is key.
Mm-hmm.
And then we also need to talk about the expertise and impartiality of the reviewers.
Of course, that's crucial.
We need qualified medical professionals
Right.
up to date on the latest research.
And no conflicts of interest.
So how do we guarantee that?
Maybe a more rigorous vetting process for reviewers.
Okay.
a board of medical experts
Correct.
to review qualifications, do background checks,
Care of.
make sure they have the experience.
Yeah, and maybe give injured workers more say in who their reviewer is,
I like that.
like a list of qualified reviewers, and they get to choose.
Give them some control.
Yeah, because they're already feeling vulnerable.
Exactly. And to avoid any bias, maybe randomly assign cases.
Oh, that's good.
No cherry picking.
Okay, so fairness, transparency, efficiency.
Those are the pillars.
But we also need to talk about communication
Oh, yeah, for sure.
and collaboration,
So important.
because breakdowns in communication,
Lead to problems.
they do.
So in an ideal world,
Uh-huh.
everyone would be talking to each other.
The injured worker, the doctor, the reviewer, everyone.
Exactly. Open and honest communication.
Okay.
Regular check-ins, status updates.
Okay, like video calls, secure messaging.
Keep everyone in the loop.
Yeah.
Address issues early on.
And maybe even incorporate mediation
Oh, I like that.
or conflict resolution.
So if disagreements come up,
Yeah.
you can work through them.
Without it turning into a legal battle.
Exactly.
So less adversarial, more collaborative.
Right. Finding solutions together.
And finally, to
Yeah.
make sure this ideal system actually works, we need feedback,
From the people using it.
right, from injured workers,
Exactly.
like survey suggestions,
See what's working, what's not.
and then might change it.
Constantly evolving.
Yeah, making it better.
Responsive to the needs of the people it's designed to serve.
I think we've come up with some great ideas
I agree.
for an ideal workers' comp system
A system that puts injured workers first.
that uses technology to make things easier
That's transparent and communicative.
and always improving.
That's the dream.
So it might not happen overnight. We can start the conversation,
Absolutely.
share these ideas, and advocate for change.
Together, we can make a difference.
Well, that's it for this deep dive into UR and IMR.
It's been a journey.
It has, but hopefully you found it informative and empowering.
And remember, knowledge is power.
So the more you know about the system
The better you can advocate for yourself.
and get the care you deserve.
Exactly.
That's all for this episode of The Deep Dive.
Thanks for listening.
We'll see you next time.